know how to.
Yes,
I'm sorry, who's
Yes, Your
who's
Honor.
talking in the back? Thank you. Do you know how to pick a jury?
yes, Your Honor.
You do? Okay, do you know how to select jury instructions?
No,
So how do you know how to pick a jury?
well, I guess there, you have people come in and, we decide whether or not we want them to.
So you have no idea how to
I have
pick a
no
jury?
idea.
Okay. And so you all discussed this and you've not come to resolution, is that correct?
That's correct.
Okay. Ma'am, you don't have to have a jury trial, you can have a non-jury trial, but if you're gonna run a jury trial, then you're gonna need to be well-versed in the rules of civil procedure for the Michigan courts. And you're gonna probably need to beef up on your rules of evidence too, okay?
Okay.
Otherwise, you have to figure out something else, because we can't have you coming in here running a circus, okay?
I understand.
This matter is gonna be adjourned since you all could not come to a resolution. A, because I don't have any proposed jury instructions for us to resolve and proceed to call in a jury. B, because I gotta cover Judge Buchanan's docket today too. So with that being said, I've set your matter for Wednesday, June 28th at 8:15. Ma'am, you can get a copy of the Michigan court rules by just Googling it online, even the rules of evidence, or you might want to visit one of the local law libraries, okay? If you decide that you do not want to have a jury trial, then you can waive jury trial and have a non-jury trial. Mr. Levine, did you provide her with your?
I did by mail, but it was at the same time that Preston, and I was just asking her if I could email her a copy. She was a little bit submissive towards that, but I can just ask her in open court if she wants an email along with the mail version, and I can do it. We do like the email version, not jury instructions.
You should just cut and paste these off of the Supreme Court website. It's just a printout from the Supreme Court.
Sure, it's supposed to retyping them, and again, limited resources from Sparrow, so I didn't really have more than cell phone to work with, but it would have been literally the same thing, just typed up in the form of the numbers and the instructions. So it's literally the same thing. It's just instead of retyping. But from us, substantively, it just comes down to express warranty issue.
Okay, I want you all to work together with and provide the court with a list of proposed jury instructions from the both of you.
All right, good.
You got a copy of your notice to appear, ma'am?
Yes, I do. Thank you.
Let's see. I need jury instructions three days prior to the date of this trial, okay?
Okay.
Any additional matters today while we're here?
Thank you.
No, Your Honor.
Thank you, you're all set. Did I give you that file?
Yeah.
You're all set, thank
Thank
you.
you.
We're on the record in the matter of Farm Bureau Insurance versus Ivantes, Adams, Shonda Mitchell, and Unknown Insurance Company. Is anyone here on that matter?
I have not seen.
Not even for the plaintiff. Anybody present on behalf of Farm Bureau Insurance? This is the second time the plaintiff's attorney has failed to appear. We're on the record in the matter of Foxland Holdings LLC versus Entree Terry.
Yes.
We muted her. File number 23-00042 LT, council appearance.
Good morning, Your Honor. Rhonda Kunkel appearing on behalf of the plaintiff Foxland Holdings.
Felicity Till, P83961, appearing on behalf of Denotra Terry, who is present with me via Zoom.
Date in the matter that we set this for a motion to stop eviction. The motion was filed by Ms. Terry indicating that she is on section 8 and 100% of her rent is covered by Lansing Housing Commission. Plaintiff has not turned in the new rental amount form to Lansing Housing. That is why payments haven't been dispersed, and that she had contacted them a few times and they said they would, but never did. She has included documents showing proof. Have the attorneys met on this matter?
We have, Your Honor.
We have to come to a resolution.
We have not. There is a. We have not.
Okay. Is there a dispute as to what Ms. Terry has provided in her motion?
Yes, Your Honor.
What is the dispute?
But Your Honor, first things first is that Ms. Terry was personally served with the copy of the summons and complaint on January 15th. She failed to show for the hearing, so a default judgment was entered by this court on March 22nd. Court rules MCR 4.201 provide that she has 10 days after entry of the judgment to file her motion. However, she filed her motion 26 days after. So we have that as a matter, and we also have the matter that Foxland Holdings is also in the process of seeking to recover possession of the property. And on the date of April 19th, which is when we had the first hearing for the recovery of possession, is the date in which she filed this motion to set aside. We do have some issues further with the fact that there was a good period of time wherein Ms. Terry had failed to provide her paperwork to the Housing Commission. And so therefore, that's why Foxland Holdings moved forward with a non-payment of rent, and then they chose to not renew her lease.
Ms. Till, is that accurate?
As far as I'm aware, as far as my understanding, Miss Terry had turned in all the paperwork that she needed to Lansing Housing Commission. The only thing that was missing was a HAP contract, which is the contract that the landlord has to sign for the Section 8 voucher. That was not signed as of December 22nd, 2022, as you can see in the documents that were provided by Ms. Terry. According to the notice provided to the court, Ms. Terry paid $0. Ms. Terry was responsible for $0 as her portion of the rent, and Lansing Housing Commission would be paying $866. And it would be unequitable for this judgment to have prospective application pursuant to MCR 6.12 C1E, because Ms. Terry is a participant in the Section 8 Housing Choice Voucher Program and is not required to pay any rent due to her income. So it would be inequitable for this judgment, for this money judgment to have prospective application. And a motion under MCR 2.612 can be filed in any reasonable time.
Your Honor, we have the matter of the fact that Miss Terry even failed to show for the hearing in the first place. So, I mean, this isn't just a matter of we had a hearing on the record. She failed to show for the hearing. So this is a default judgment.
May I speak, please?
And if you'd like,
I can.
yes.
Okay, so can I say this in my defense? Fox Landing had sent me 3 different court dates. I figured the April 19th trumped them all. I did not know they were for different things. I thought they were all pertaining to them saying I owed money and wanted the recovery of the, not renewing the lease. So they gave me 3 different court dates. So I assumed that April 19th was because I had got 3 different ones that they were being rescheduled and this was the final one. The reason I filed on April 19th, that's the day I found out that that Fox Landing had a money judgment on me. And I did not know that until I went to court April 19th. Okay, when I found that out, that's when I went and filed all the paperwork that I needed to stop the judgment.
Okay, thank you. I did have a note here that at the time of the last court date, which was March 22nd, that there was another eviction pending. We've had this matter happen multiple times, a few times involving Fox Land Holdings, and it causes confusion. When you file more than one eviction and you're sending multiple notices to laymen who don't have a knowledge of how the court process works, they don't realize that you're filing more than one eviction and they have several court dates. It has caused a cluster of confusion for the court because we have people appearing on different days and not knowing which one they need to appear. And in certain instances, I've dismissed one because I think it is an unfair advantage to the tenant to have multiple evictions pending at the same time. Fox Land Holding need to figure out how they want to evict people and proceed that way. As it relates to the motion for the equitable nature of having this judgment applied, hey, I think that she has a good reason why she missed court, because she had another court date pending and that caused her some confusion. But also, I want to know, I don't even know why Fox Land Holdings would not have signed this paperwork as of December when this paperwork was submitted to them. That didn't appear to happen.
Your Honor, it's a matter of Fox Land Holdings was being advised that Ms. Terry had not completed her paperwork. So there was a delay in that matter. And then when the matter continued to drag on, then Fox Land Holdings chose not to renew the lease. They did attempt to negotiate with the Lansing Housing Commission to do a short-term contract, as well as a short-term lease that would have matched it, just in order for them to allow the time period so that they could actually pursue seeking to not renew her lease in total.
Okay, well, the records that I have that are attached to the motion indicate that the holdup was Fox Land Holdings. I don't have any records that show or support your statement that it was Ms. Terry that held it up. So for that reason, and for the fact that there was a confusion causing more than one eviction pending at the same time, ironically, she appears to court the very same date as her other court date, which is the date of this motion, supporting her statement that she thought that that April 19th date was trumping the other dates that she had received. I'm going to grant the defendant's motion.
Thank you. Thank you.
Judge, do you want me to prepare an order?
Yes, please.
Okay.
Thank you.
Thank you. Any additional matters for the record?
No,
No, just clarifying, Your Honor, that we do have the second hearing for the recovery of possession set for June 13th. I understand
other
this in
file?
yes,
Yes,
thank you, Your Honor.
no problem. You're all set for today. Thank you.
Thank you.
Thank you.
Yeah. thank you.
Motion. Can you mute up, please? Let's see. Mr. Goodman, which matter are you here on?
Good morning, Judge. I'm here on Grand Ledge Emergency Service versus Sibley.
Is Sibley here?
Yeah, he's in the mechanic, sure.
Okay, did you all meet already?
Yes, we did. We talked in a breakout room. We were unable to resolve the matter. We have agreed on some dates for purposes of pretrial.
Okay, well, I just need a joint pretrial statement from you. Did you prepare a joint pretrial statement?
We have not. We talked today. We exchanged email to Sibling. I can email you a proposed joint pretrial statement, and then we can submit it to the court.
Very good. We'll have my court officer will send you our standard form if it makes it easier for you to fill that in. And then that's what we use to kick out our scheduling order, okay?
Okay, great, Judge. Thank you so much. We'll have that back to you. Mr. Sibley, I'll get that over to you as soon as I receive it from the court, and we'll get it back to the court right away.
Do you have any questions today, Mr. Sibley? Okay.
Thank you,
You're all
Judge.
set. Thank you. Oh, that's one I just. No service. On the record in the matter of Cedar Place Apartments versus Jacob Cow. Why? Okay, file number is 23-00445. So you can come up to the table. LT, council appearance, please.
Morning, Judge. Christopher Asphalt, 53129 for the plaintiff.
Okay, and so you don't have an attorney, correct? Today is the date that is set for a motion to stop eviction. You filed a motion to stop the eviction. You stated that you wanted to let the court know the reason of the default to pay the rent. The default is that you failed to come to court. Did you get notice to appear in court, sir?
Yes, I got the letter that I had to go on doing, for which means that I read it, but that when I read it, I found it. Second later, so I found it that, I read the letter, say that I have to go on Zoom, so I do Zoom, I get Zoom on my house without coming down here, and I didn't hear people, I saw the people in the court, and I didn't hear what they talking.
You saw us, but you didn't start your audio.
Yeah. So that day, so I went to the manager and I asked the manager, so what happened? She told me that I will let you know on Monday. And then on Monday, I received the letter that, I have to be dated for, after dated for.
Okay,
After dated for, that's why I came for a motion. I don't know.
okay. Motion to set aside his default because he did not know how to work Zoom is granted.
I'm sorry, Judge, I didn't hear what you just said.
Granting his motion, he had a user error. He logged into Zoom, but he never started his audio. So he never proceeded with the court dates, and that happens often. So I'm going to grant his request set aside as default and set this for a hearing. Sir, I'm gonna get you information so you can contact legal services. So you can do an intake with them to see if they'll provide you representation. And then you can also contact our eviction diversion facilitator. He is downstairs, one floor, Mr. Rosa, if you'd like to find out if there's any resources that can help you. You should appear in person since you don't know how to start the Zoom, okay?
June 21st at 1:30.
June 21st at 1:30 is your next court date. Do you have any questions today, sir?
Fine, yeah. Yeah. I think the amount, so why is the amount is $6,000? Because
I
the
have no,
amount-
I have no idea why the amount is, or even what the amount is. We'll address that at a hearing.
Okay,
Today was just to address your motion to set aside the default. I'm gonna grant your motion. We'll set it for a hearing and then we can get into discussion about what's owed and why it's owed. But you should probably contact legal services and contact our eviction diversion facilitator, okay?
I just heard that because if I find that amount, so I can pay, so that's why so to have the right amount. So
You wanna know what the correct amount
the
owed is?
correct amount, if I got
Can
the
you
money.
provide what he owes?
It appears, Judge, he owes $7,359. No payment has been made since November.
So for how many years? Because I paid, I was sick, so, and I was down there, so I didn't work, I just started working on paper this year.
Yeah, you should stop by and get a statement or get a list of what you owe, and what was paid, okay?
I will discuss it.
Okay, thank you, sir.
Your Honor, was the time of the hearing on June 21st? Did you say 1:30?
That's correct.
All right, thank you.
Thank you. On the record in the matter of Waverly Place Apartments versus Rachel Reynolds and all other occupants, file number 23-00293 LTD. Council appearance.
Good morning, Your Honor. Just appearing on behalf of Place for the Place Department.
Okay, Rachel Reynolds.
Rochelle.
Michelle Reynolds, thank you. Do you have an attorney?
No.
Okay, today was the date and time that was set for a hearing before Judge Buchanan, who's tied up in a trial. I have a consent order of conditional dismissal here. Ma'am, it's alleging that you are agreeing to pay the amount of $3,250 for past due rent, $162 in court costs, plus a $25 late fee, for a total of $3,437. And that you'll make that payment by May 31st. Says defendant makes monthly payments in the amount of $1,315 on or before the 30th of each month for May, June, and July of 2023 to be caught up. So it's gonna break those payments down, correct, Mr. Klug?
Yes, Your Honor.
Okay, is that accurate as to what your agreement is?
Yes.
Okay, and so the plaintiff is agreeing to dismiss this upon the condition that you will do those things, that you'll pay that total of $3,437. You're gonna be making monthly payments of $1,315, the 30th of each month, May, June, and July, correct?
Yes.
You understand that partial payment won't satisfy this judgment. You have to make payment and comply in full, correct?
Yes.
Okay, I have an agreement here indicating that you understand your legal rights and that you're waiving them. So you understand that you have the right to retain counsel to represent you in this matter?
Yes.
Okay, and legal aid was available, but they didn't grant you representation, correct?
I'm sorry.
Legal services did not grant you representation in this matter, correct?
No.
Okay, you're waiving your right to representation at this time?
Yes.
You're also waiving your right to have a trial?
Yes.
Okay, you have 3 business days from today. If you leave here and realize you misunderstood any of the rights that you're waiving, you can return to the court, request to have this set aside. We'll set it for a hearing, okay?
Yes.
Do you have any question? Any additional matters for the record, council?
No, you're right.
You're all set, ma'am. Thank you. We're on the record in the matter of Waverly Place Apartments versus Emma Reinhardt and all other occupants. Maybe not, default?
Default, yes.
Okay. Default's granted.
Thank you, Judge. Have a good rest of your day and
Thank you.
don't get too many Judge Buchanan's cases this morning.
Well, the agreement is I'll handle them. I'm not doing any hearings. No hearing.
Well, good luck.
Thank you. Okay, we're on the record in the matter of Kurt Tipsy versus George Rutzman, file number 23-00109 GC. Council appearance. Okay, Mr. Rutzman's finally made it to court on time and not dragging it in late. You're early today. Okay, this is about the third, fourth, or fifth time I've set this pretrial. We finally got all the parties here. Let's see, did you ever complete a joint pretrial statement?
No, I started to, Your Honor. He told me he was gonna ask you to allow him to have an attorney.
Oh, we've been through this, sir. On December 14th, 2022, adjourned for 2 weeks to allow defendant to seek counsel.
Yes, I'm trying to get counsel. I talked to him yesterday.
I'm not adjourning this anymore for you. If you didn't get counsel in the last 6 months, he's gonna have to show up at the pretrial and file a motion to adjourn any dates. We're doing a joint pretrial statement today. It took way too much for us to get you in court on time when they're here for me to adjourn this so that you can get an attorney. You had more than enough time to get an attorney, sir. You understand that? So you can still get an attorney, but I'm not adjourning it for you to get an attorney because it's already been adjourned multiple times. So we're going to do your joint pretrial statement today. If you do retain counsel, they can file a motion with the court or they can stipulate with his attorney to reschedule any of those dates that don't work for him or her, okay?
I think I understand, and that's why I'm wanting to, get legal aid. And I talked to legal aid, they told me to come down, just say yes and get back with them right away. And that's what I wanted to do.
They told you to come down and say yes to what?
Yeah, to seeing them.
Okay, so have you gone and done an intake with legal services?
Yeah, I talked to them, they sent me here to, this date. They looked it up because I had them a long time ago. And I've been okayed with by them. So,
Okay. They sent you to court, you said?
no.
They sent you where?
They knew at the court date and told them that, it's tomorrow, which is today. Said, come back right after I talk to you.
Okay.
Say yes for E.
Gotcha.
Legal aid.
Okay, well, you don't have legal aid yet. And if they do retain or take your case, they know how to stipulate and get in contact with plaintiff's counsel to readjust any of the dates that don't work for them. But today, you're going to complete a joint pretrial statement, okay?
I'm not prepared for it, but okay, whatever.
What do you mean you're not prepared for it? This is the paperwork that we're completing.
Is that what the form is?
Yeah, it's you're just doing one form together.
Yeah, I wanted to have somebody look at it.
I'm gonna look over it when you're done. But you all need to work to get those together. If you have issues with the pleadings, then that will be stated. If there's a time that's needed for discovery, that needs to be stated. Any counterclaims that needs to be stated, and then I'll review it with you. But you need to do it today because This matter has been set 1, 2, 3, 4, 5, 6. This is the 7th time this matter has been set. I'm not resetting it.
Can I take
You all can go to private-
Bring it back, can I bring it back?
No, you all are gonna, no, you're not leaving here with it. It's gonna get done today while you're in the building. Yes, you all can go, there should be a conference room that you can go into, okay?
Thank you.
Thank you. What's that?
Good.
I think so.
Okay, thank you. Okay, we're back on the record in the matter of Titsy versus Runciman. I do have a pretrial statement here. It says plaintiffs issues or damages to the rental house and cleaning costs. Defendants issues to be litigated are loss of antiques and kitchen items. There's no issues with the pleadings at this time. That's correct, sir? Do you know what pleadings are?
No, but
So that's the paperwork that was filed, that you should have an issue with their complaint, the form in which it was filed.
yeah, I got a lot of them.
No, not do you dispute it, but do you think it doesn't comport with the court rules, and you want them to amend it or something to that effect?
You know, to my knowledge, I can't see that.
Okay, so as of right now, they're complete. If your attorney comes in, I'm gonna grant grace and let them file any motions as necessary, okay? Okay,
Can you just go through that again, what you just said?
what I just said, I said as of right now, we'll say that the pleadings are complete. But if your attorney comes in, they'll be able to file what they need necessarily, because they may come in and file a counter complaint on your behalf. I'll grant them some grace with the timeline to do that, okay? Okay. Motions on this should be filed as of right now by June 15th, 2023. There's no issues to consolidate. Nobody has admitted any facts at this time. It says exhibits, the plaintiff has photos, leases, and invoices. The defendant has some photos and paperwork. Those exhibits will need to be exchanged a week before trial. Discovery. Put the discovery cutoff for the same date as the motion. I'm gonna move the motion to 7:15.
Sorry.
That way you got time from 30 days from the end of discovery to file a motion, okay?
Sounds good.
Again, these dates can be changed if you have an attorney, okay?
I will have that one here.
Okay, sounds good. Okay. It says expert witness, no maybe. What's that mean?
I said no, and then after I wrote that, I guess. we
Okay,
crossed
what
that through.
do you
He said
think you need an expert
he
witness
might
for,
have
to maybe
somebody.
talk about the antiques or?
Yeah, the value of the antiques is just not my thing. I'm
Valid.
an antique dealer. I've been doing this for, 10 years. And I
Okay.
know the value of some things. He calls everything junk. It wasn't.
Okay, sounds good. So we'll put maybe as to defendant in a counterclaim, because you haven't filed a counterclaim, I don't believe.
Yes, that's what I gotta do, because it's gonna be a lot more than what he's asking. He's asking for 5,000 something. And
Damages, I just see yes, but I don't know the amount. How much is plaintiff seeking?
I believe it's $5,914.
$5,914. And what if you filed a counterclaim? Well, let's just put this, defendant intends to file a counterclaim, and then you'll have to put the amount in your counterclaim.
that's a lot more than that. Trust
Right,
me.
I get it, but guess
Yeah.
what? The counterclaim is gonna need to be filed relatively quickly, because we can't come in a week before trial and file a counterclaim, okay?
Yes.
There's no joinder claims. We think the bench trial will be about a half day set after, we'll move that to after the 5th. Well, if you file your we'll set it after the 15th, okay, of July.
Your Honor, I'm gone the first 2 weeks of August.
Okay, I'll note that here.
Okay, thank you.
We'll set it after 8:15.
Thank you.
Okay. No other issues at this time. We're not gonna set this for Casey Val. We don't believe that this could be set or would be useful to go to mediation. Is that correct?
Correct.
Okay. Do you have any issues or concerns or questions about this form?
No, we'll run it by the attorney and I'll go through it.
Okay, from what I've seen here, you've done an excellent job. You've not admitted anything on here. You've not put anything in here that binds you or prejudices you, if that makes you feel better, okay?
No.
Okay, so, and I'm giving you time to still get an attorney and then we can amend these dates. But we need to get something moving now because this has been tied up. If you're gonna have an attorney, we need, let's see, they need to file their appearance no later than the 15th of this month.
By the 15th month, they have to.
They need to appear in the case. We don't have an attorney appearing for you at this point. And once they appear in the case, then they can get in contact with the plaintiff's attorney and work out, because they'll need to file their counter complaint and serve it, your counterclaim, and they'll need to serve it on the plaintiff, okay? And so that will change all of these dates because now we have to deal with the counterclaim, okay?
Her address.
You do have.
That does address. Do I have your address?
It's on the
It'll
paperwork.
be on the paper, okay.
Yes.
Do you have any questions today, sir? Okay. So what we do with this is we have the civil department generate a scheduling order. So you'll get in the mail your next court dates. You need to pay attention to those, sir, because you don't really have a great track record, okay?
No, well.
And
be on time.
we can't keep tying up their life because you don't show up to court, okay?
That's in the past. It won't
Okay,
happen
very
again.
good,
Okay,
very good.
From today.
Mr. Huntsman, what's your
I guarantee that.
okay, just want to make sure.
Listen, I've worked this one place and if you're late, you know, you get off. I've worked there at Dean Transportation and never been late, never. That's 10 to
All I
10 to
know is
12
that.
years. So I've got a good history except for here.
Yeah, you don't have a good history here.
I know,
I mean, I
that's
remember
what I'm
one
saying.
time we were in here waiting for you and you didn't show. And then my staff and I was going to lunch and then we saw you down the street. And we were like, isn't that
Well, I was
Mr.
late,
Rutzman?
Yeah, I was late, it was up there, so
Yeah.
half an hour, I thought, you know, and he didn't show up either. My guy that.
No, that was after they thought the case was dismissed.
We were here in loud.
Yeah. They thought the case was dismissed, so they didn't
Well, I
know.
thought they did Zoom and I did Zoom once, I didn't understand it, like you
Yeah,
said, a
just
lot of
come
people
in.
don't understand.
Yeah, it's
I mean, it's new, eventually.
I
that's-
didn't understand it until I had to use it every day.
Right.
Yeah, I mean, I see that you did say that that's common.
It's
People
common.
don't, I mean, eventually that all be, you know, in the future.
Yeah, well, right now Zoom's here to stay.
I was
Yeah,
gonna
oh,
say,
Yeah.
half the stuff already.
Yeah.
so.
I'm going through eviction up in Frankfurt. I'm moving to Frankfurt. I'm going through an eviction of people there and I've been there, same tenants there for 45 years. And I outlive the mother and the father and the two sons that live in there. And they won't leave because I charge them $300 a month. And the realtor in town of Frankfurt says it should be $2,000.
It's a great deal, Mr.
$2,000 a month. And I did it so they didn't have to run back and forth. And I was nice to them. Now they won't leave.
Well,
I can't blame them.
well, I wouldn't leave either for $300 a month.
Well, that's why I got, that's why I'm going to the court.